is recorded and live stream on social media. Good to see many of you here with us today. Welcome to this webinar about child rights and climate change, this time focusing on the responsibilities of Australia to its Pacific neighbours and beyond. My name is Noam Peleg, and I'm a senior lecturer at the Faculty of Law and Justice at the University of New South Wales. And I would like to pay my respect to the Gadigal people of the Eora Nation, which is where my office is, and to pay my respect to the elderly, past, present, and emerging, and to extend my respect to any Aboriginal or Torres Strait Island person who join us today or who watches the recording later today. And you're all welcome to add your own acknowledgement of country at the chat function as well. This webinar is a collaboration between the Diplomacy Training Program, Youth Law Australia, and Australian Lawyers for Human Rights, and is part of a longer series of webinars dedicated to the rights of children, and a special mini-series that we are having in the last couple of weeks, which is dedicated to issues concerning climate change and child rights, where we look into General Comment number 26, that that was published by the UN Committee on the Rights of the Child back in September. This is our third and last webinar of this mini-series, and you can find all previous webinars at the DTP YouTube channel. Apologize for that. Before we proceed, a few housekeeping rules. It would be great if you can mute your microphones, but keep your cameras on, so we can have an engaging seminar and webinar this afternoon. Feel free to add any questions or comment at the chat function at any time during the talk. And at the chat, you'll also see some links to relevant documents and websites that will be mentioned during the presentations. And obviously, at the Q&A session, you can use the chat function to ask any question to any of our speakers. General Comment number 26 on child rights and the environment calls for urgent action to address the impact of climate change on children. And as COP28 is about to finish, it is time to look at the implementation of one of the most innovative elements of the General Comment, which is, and I'm quoting, the importance of international cooperation between high-income states, duty to support and adaptation and mitigation efforts in developing countries, and by contributing to financial mitigation and adaptation strategies. And that these strategies take account of the obligations to realize the rights of children of all state parties to the UN Convention on the Rights of the Child. So this is going to be the focus of our webinar today, and we aim to explore the question of international cooperation, including Australia's aid program and the need for children's voices to be heard in all mitigation and adaptation processes. And we have three excellent speakers that will address these issues today. We have Justice Nelson from Samoa, who will outline the challenges to Pacific Island children in identifying what General Comment 26 has to say about these issues and what the expectations of Pacific Island states for actions by Australia. Tamara Logan from Save the Children will discuss the role of NGOs in shaping the responses to the rights of children affected by climate change. And Cynthia Honuhi, a founding member and current president of youth-led NGO Pacific Island Students Fighting Climate Change, will share her experience in advocacy in this space and what she and her organization expects from governments. And I will present each speaker in more details as we go along. So as Judge Nelson struggles with some technical issues, I see you're already here, perfect. Technical issues have been resolved. So we'll kickstart our webinar with his presentation, not before I introduce him properly. So Judge Willie Clarence Nelson from Samoa has a long and impressive career in the judiciary and beyond. He has 18 years of experience as a presiding judges at all levels in Samoa, including being a senior judge of the Supreme Court of Samoa. He is currently the Vice Chair of the UN Committee on the Rights of the Child, and throughout his legal career, Judge Nelson has been a staunch campaigner for the rights of children. He was instrumental in establishing the Samoa Victim Support Group, a group formed to support victims in the area of, especially in the result of domestic violence and sexual offending. He was a member of the working group that drafted General Comment number 20 of the UN Committee on the Rights of the Child, which dealt with the rights of children during adolescence, and General Comment number 21 that dealt with the right of children in street situation, and was part of the working group that planned and coordinated the committee's 2016 Day of General Discussion on Children's Rights and the Environment. Judge Nelson, the floor is yours.
Thank you, Norm. I just want to check that you can see me and hear me. Yes?
All good.
Excellent. Thank you. You know, we are far away in the Pacific and technology can sometimes be a challenge. Well, thank you for the invitation to participate in this webinar. I need to make a correction that my term on the Child Rights Committee has now come to an end. It finished this year. So I'm no longer vice chair or a member of the committee. But as I was in the working group that formulated GC26, I think I can speak to one or two things about the general comment. And it's a pleasure to be here and to be part of this webinar. Look, I think, Norm, from the Pacific, the biggest challenge is this. You know, we now have this general comment number 26. It's probably the only general comment that has had such a large input from children. There's like 16,000 children gave their views in one form or another into the formulation of the general comment. And in addition to that, we received hundreds of submissions from NGOs, from various organizations and from state parties. The general comment has been launched, and we launched it, I think, 2 weeks ago here in the Pacific, a Pacific launch. And that's particularly important because, as we all know, climate change affects the Pacific in very drastic and very real ways. So we now have this wonderful document. I mean, a lot of work went into it. A lot of people invested time and energy into it. And it's got a lot of detail and a lot of content. But our problem right now, Norm, is that firstly, children in the Pacific are not very well informed about their rights as a general rule. And that includes general comment number 26. And it's something I think we are going to have to address in the near future. And it's not only children, it's also governments in the Pacific. If you talk to people in governments in nations in this part of the world, and you mention general comment 26, probably only half of them will know what you're talking about. So there's a big challenge right now, and probably in my view, the biggest challenge right now that we've launched the general comment, is an education challenge, is to educate the children, to educate the public, and to educate the governments that the general comment is aimed at. And this may take, you know, some time to do, but it is most essential that we do that. But all is not lost, no. I mean, you know, the general comment doesn't sit in a vacuum. The general comment is only the latest weapon, if you like, in the child rights environmental area. There are other weapons out there. For example, I think we are all familiar with the OPIC case that was brought by 16 children to the committee a few years ago. And the significance of that case is not only the fact that children brought it as a complaint under that optional protocol, but also it was the first time the committee or any international treaty body committee has recognized transboundary harm as a principle. And I think that makes it a significant step. And I foresee that there will be in future perhaps other challenges because that case failed because they didn't exhaust local remedies. But if they can overcome that hurdle, I think there's nothing to stop future cases being brought before the committee under the optional protocol. And that's not all. I mean, we have a current case. Pacific nations are taking a current case to the International Court of Justice, as you are well familiar with. In the International Criminal Court, there are moves to make ecocide a fifth crime of the Rome Statute. And if those moves are successful, and it's generating a lot of interest, this may have tremendous international implications in respect of children's rights. And even in our region, as you know, there are cases in Australia. I mean, the Sharma case is a classic example of litigation being used as a means for recognizing children's environmental rights and the duties of state parties. So we have a lot of options other than the general comment itself, and I think we need to bear that in mind. That it's a large playing field, and we do have these other sources that we can call upon. But in relation to the general comment itself, it's a large document. I don't think we have the time and space to sort of drill down too deeply into the general comment. But I want to highlight perhaps 3 or 4 areas from the general comment that I think will illustrate the problems that we have in the Pacific and the challenges that children will face in respect of implementing the general comment. But there's also positive aspects. The first one I want to talk about is the fact that the general comment, what it does is it not only serves as a guide, but it actually points to specific areas that state parties need to take action in and that children can take action in. And one of these areas is child rights impact assessments. That receives prominent mention inside the general comment and is something that some state parties in the world do, but most of them don't. But because it is now contained in the general comment, it's a duty that is now being imposed on state parties that before they can undertake any environmental decisions, whether it's legislative decisions, policy measures, whatever, that they undertake a child rights impact assessment before they do this. Now, this is quite significant, but it will be difficult to implement because in order to have that kind of thing, you need national legislation. You need state parties to pass legislation that will require these things to be done. And then secondly, it's not just about making a law that makes it mandatory, but it's also about budget support to allow it to happen. No good having a nice law if you can't back it up with budget support. And this is an area where I think international cooperation would be very useful. For example, you know, if a country cannot undertake a child rights impact assessments, we have international donor partners. For example, Australia. And there are many international donor partners in the Pacific operating in the Pacific region that we can call on to help with budgetary support to undertake these assessments. The other issue, of course, is even if we could have budgetary support, technical support is also required. Some of these things can be very high tech. I mean, if you're going to start, for example, looking for the possibility of drilling undersea oil drilling in your maritime zone, you're going to need some very high-powered technical expertise in order to conduct an impact assessment on that kind of move. The second area I think that certainly that I would refer to in the general comment is it is a basic pillar, as you know, of the general comment, and it stresses the issue of consultation with children and how it is so important that their voice be heard in relation to environmental decisions or decisions that will impact their rights to a safe and healthy environment. And, you know, in this respect, this kind of consultation, and I'm thinking it can be done locally in country. I mean, what is so difficult about, for example, the government circulating a questionnaire in the local schools, asking children what they think about what they are proposing to do, whether they're going to pass a law or whether they're going to implement some kind of new policy. Something like that is not going to involve a lot of technical expertise, doesn't require a lot of budget support. It only takes the willingness to do it. And it can be done at local level. And I think that's the sort of thing the general comment envisages, is that this can be conducted locally, can be done by state parties locally, especially small island states who have very poor budgets and very limited resources. They can do it. I've heard of this being done as part of a school project. A couple of schools here have done projects on, plastic littering on the beaches. And that might be a school project, but it is also a way to make children aware of their rights, and also for them to give to the authorities their findings, their recommendations, and their outcomes. Or alternatively, people can call on the Children's Advisory Team, the CAT, which is the team that was originally formed to advise on the general comment, but is now a standing team. And I understand that they are continuing with their work. I mean, they recently produced the child-friendly version of the general comment, and they are working on a lot of other projects. And there is another source of where children can be consulted before governments take measures. And on that advisory team, children from everywhere. They're all represented from different parts of the world, including one from the Pacific, Aniva Clark. The third issue I want to talk about in relation to the general comment is the matter of access to justice, because I think this too is another area that is important to the general comment. And when we talk about access to justice, sometimes we all use it in different ways and to mean different things. But I would say that for the purposes of the general comment, we can look at it in two parts. One is that it's all about, firstly, consultation and participation in decision making. And secondly, it's about child-friendly complaints mechanisms, where there has been no consultation for one reason or another, or where a problem now arises and children want to take some action. In relation to consultation and participation, again, I think governments and even businesses, even the commerce, the commercial aspects of any country, can create spaces for dialogue with children and for consultation with children. I'm thinking of Aniva Clark when she first came onto the scene as a child rights activist. Their school, it was because their school conducted a project to clean up the mangrove swamps behind their school. And what they did is they went to one of the local businesses and got the business to sponsor their project and give them the cleaning materials and give them what they needed for it. And that was such a great example of how local businesses and local children could cooperate in that sector on that particular issue. And it was a tremendous success. These are also things that I think governments, particularly governments in this region, can look at, is encouraging those kinds of efforts and creating space where this kind of cooperation can occur between local businesses and children in relation to their projects. And of course, the governments would also have to cater to the other side of access to justice, which is child-friendly complaint mechanisms, so that children are able or have the capacity to take action against businesses again or against governments for breach of their obligations. The last thing I want to do quickly, Noah, is also to say that I think the other use of the general comment is the fact that it can be used now in litigation. Now that the committee has issued the general comment, we can actually use it in domestic litigation and in international litigation. I think it came out too late for the Sharma case, but certainly for the litigation, for example, the Torres Island litigation that's on now. It would be useful for them. And certainly for the ICJ submission. It is now a piece of international law that can be used and quoted to litigation tribunals. Lastly, I mean, there are many other areas, Norm, under the general comment, which provide for specific measures to be taken, you know, like transfer of green technology, international environmental financing, which requires that part of it be allocated to child-focused programs, et cetera, et cetera. There is a lot of content in the general comment. I think the general comment itself, a close study of it would actually, you'd be able to pick out all these options that the general comment points to in how state parties can be, you know, persuaded to live up to their child rights obligations. I think you also wanted me to say something about the Australian aid to the Pacific and Pacific expectations. I can say that very quickly. Really, it's an issue of mitigation and adaptation. In terms of mitigation, what the Australian government should be doing is it should be living up to its commitments under the Paris Accords. All of them should be doing that. And that is the best mitigation action that they can take, apart from closing all the coal mines tomorrow. But I don't think that's realistically going to happen. In terms of adaptation, we now have this huge green climate fund, which may or may not soon become a reality, but certainly that fund is undertaking projects in the Pacific area. And one thing that I think the Australian aid program should do is to target support of measures being undertaken for adaptation. Like I think right now they've got a big coastal adaptation project in Tuvalu, where they've sort of, the science and the technology has finally told them that putting up concrete walls is not going to solve the problem in Tuvalu. So they applied a lot of technology to it, and they and also for the first time they started talking to the locals, who knew a lot more about the environment than other people. And with a combination of that, they've come up with a coastal adaptation project that constructs new measures and new ways that they use natural structures and built structures as a buffer against storms and rising sea levels. I think also under that program, there's students. I think there's students at your university on scholarship that they are funding for scholarship. I mean, these are great initiatives. These are the sort of things that the Australian aid project should, in my view, that's what they should support. Look, I'll leave it there. I think we want to encourage a sort of a dialogue, but those are my very quick thoughts in no particular order on the issues you asked about. Thank you. Over to you.
Thank you very much, Judge Jensen, for this very comprehensive and detailed overview and insights into the utility of the general comment and what can be done in the future in realizing child rights in the space of climate change and how best to utilize what the committee have said in general comment. I think we'll come back to some of these issues that you've identified in the next two presentations, and also, if time permits, during the Q&A session that we are planning to have at the end of the presentations. So without further ado, we'll move on to our second speaker, who is Tamara Logan. Tamara is the Pacific Policy and Advocacy Advisor at Save the Children Australia, working with Pacific country offices to promote and uphold child rights. She has 20 years experience working with NGOs, government, development partners in community-based substantial development, including working with the Secretaries of the Pacific Regional Environmental Program, the Asian Development Bank, and UN agencies. Most recently, Tamara has returned from living in Hong Kong for 5 years, where she was studying Mandarin and undertaking a JD program. Tamara, the floor is yours.
Thanks so much. I'm just going to share my screen, so bear with me, everybody. Firstly, thank you very much to the Diplomacy Training Program for the opportunity to present today, and also the privilege of presenting with two excellent speakers, and Whawhatai Lava, Justice Nelson, for that comprehensive overview. And I feel privileged to be able to present alongside you, considering your contribution to GC26, and also Cynthia as well, as one of the future leaders of the Pacific region, and her work as a climate advocate for the Solomon Islands and the Pacific as a whole. So today, really, I'm just going to go through and touch very briefly on how we think maybe the GC26 will be most effective in the short to medium term. And we understand that coming to a point in international law where we have a document, an authoritative piece like GC26, which makes a connection between climate change and children's rights, is an important point in history, because for the first time, what we're acknowledging is that climate change is actually about the future of children. It's about it's a development program. It's not just about how the world is changing and the impacts on Pacific countries and the rest of the world. It's looking at exactly how can we actually make a change and what are the inroads to do that. And first off, and I know that people are probably familiar with this, but as we all know, that the written submissions for the International Court of Justice advisory opinion on climate change are due on the 22nd of January next year. Pacific countries are working very hard to try and create submissions for this. And basically what it is looking at what the obligations are around climate change and the legal consequences that some countries owe to other countries, especially small island developing states. So I think if we are going to look at how an authoritative piece like GC26 will be most useful, I would suggest that we look at how we can apply it to this as well. And Justice Nelson has touched on this as well in his presentation, where it all began, giving credit where it's due. And Cynthia will speak to this as well, but Save the Children really wants to acknowledge the work of the Pacific Island students fighting climate change and the incredible achievement that they have with the government of Vanuatu to get this advisory opinion happening and before the court. As we know, Vanuatu is a global leader in climate policy, and we also wanted to acknowledge the work that they're doing currently in COP in raising the voices of children and the rest of the world to the rest of the world. So I'm just going to stick through that because really to get to what we're talking about. And I think the question before the court is, what are the obligations of states? So I won't delve too much into that. And Justice Nelson has given a fantastic overview of what that might be. But I think also this is a really good opportunity for Pacific countries for the first time to use that body of evidence and that body of opinion to start looking at what the obligations of other states might be. As an international NGO, Save the Children won't be making a submission to the court. We don't have the standing to do so. How we can support is we are supporting the Pacific submissions. So we are working closely with the Pacific Island governments of Papua New Guinea, Solomon Islands, and Vanuatu to ensure that children's voices are included within their submissions. A key consideration around this is that member states are under no obligation to consult future generations, so children and young people. However, children and young people under the Convention of the Rights of the Child, specifically Article 12, have a right to be consulted on issues that concern them, especially around their future. The Convention of the Rights of the Child is an important piece of international law that we can draw on when we're looking at what the rights are of children and how we can actually use GC26 to bridge climate change and CRC in country as well. Speaking specifically about General Comment 26, excuse all the text, but I have tried to highlight all the interesting bits, so please go to the highlights. This PowerPoint will be available if you want to look at it at some other point as well. It's the first international instrument establishing the link between environmental degradation, climate change, and children's rights. It's positioning children's rights as a development issue, as a climate change issue. It's saying for the first time that children cannot uphold their future and cannot access their rights unless we address climate change and the environmental degradation and impacts that are posed by climate change. It's a benchmark. It's considered the first time that we can start measuring progress, not just of governments, but the corporate sector and other partners as well, to see if how they're accountable to the governments, to the children, to the communities that they're working in. It provides guidelines. It's an authoritative piece. How binding it is will, I suppose, when we start kind of delving into how it's going to be used, we might be able to develop a body of opinion about what its use might be, specifically around things like the International Court of Justice Advisory Opinion on climate change. And it actually says for the first time that climate change and not doing anything to act and not doing anything to kind of mitigate its impacts is a violation of children's rights. Just a little bit about Save the Children, what we're doing. So we are supporting state submissions through ensuring that children's rights are included. We are drawing heavily on the GC26. We understand that this is an incredible opportunity to highlight this incredibly authoritative piece and to create awareness about climate change and children's rights. We're also facilitating child-led and youth-led initiatives. And Justice Nelson touched on this a little bit about drawing out children's voices and ensuring that they're asked about their opinion. And we're advocating and supporting ongoing climate change and human rights dialogues. Thank you very much. Very short and sharp. If you have any questions, very happy to answer them at the end. And of course, this PowerPoint is available. And if you do require more information about the work that we're doing, please don't hesitate to get in touch. Thank you.
Mara, thank you. Thank you very much for this presentation. And as suggested, I mean, the PowerPoint will be made available like the rest of the links and information that we are posting on the chat. Claire Sidotti from the DTP will share, will share this information with everyone who will register to this webinar today. And if you have any questions to Tamara, also please feel free to pop them in the chat so we can discuss them today in this meeting when we are all together. And then now, last but not least, let's move to our third speaker, Cynthia Honihui. She's an Indigenous young person from Solomon Islands. She's a founding member and the current president of the youth-led NGO Pacific Island Students Fighting Climate Change, an organization that has established 4 chapters in Fiji, Solomon Islands, Vanuatu, and Tonga. The organization's core campaign is to seek an advisory opinion from the International Court of Justice on climate change and human rights, and we've heard about this advisory opinion already. She's currently studying an LLM here at UNSW. The floor is yours, Cynthia. Thank you.
Thank you. It's very early here, so excuse my energy. I'll try to bring the young people energy, but please bear with me. First of all, thank you to the organizers for inviting me to this webinar. I appreciate it very much. So I don't have any PowerPoint presentation, so I'll just speak. To begin with my presentation, I'd like to recount an experience that I had that I see as one of the drivers and motivation for the work that we do. So in 2014, when I was still in high school, there was a month, I remember, when there was heavy rainfall for a few days. It was so intense that it resulted in one of the most devastating floods that we experienced in the Solomon Islands. I remember that evening, I was sitting outside my parents' house when I saw a young mother running past our house with a baby in her arms, with no umbrella and no proper warm clothing on both of them. She ran past so fast, I didn't have time to gather my thoughts to ask why she was running with her child without any proper covering from the rain. And soon after, I saw another group of mothers running by in the same situation without an umbrella, but some bags of clothes over their shoulder and the children in their arms. It was not until later that I learned there was flooding down in the valley from us, and that these mothers were evacuating and rushing off to find shelters at relatives' homes just down from us. The image from that day has been engraved into my mind. Even speaking about it now, I can clearly see it vividly in my mind. It speaks to the point that climate change is causing unprecedented children's rights crisis. And we all know this, and there is a need to address climate change. And we really want our children, particularly in the Pacific, to enjoy their rights as freely as possible. If you look at the Pacific context, these are small island nations at the front line of climate change, but also are the ones leading at the front line of climate action. Our Pacific leaders have been very consistent in calling for more ambitious climate action on a global stage. Our youth have built on this. This can be seen in the youth leadership in terms of climate actions. For example, the ones leading and calling for fossil fuel non-proliferation treaty and our own campaign of seeking an advisory opinion from the International Court of Justice to give clarity on the obligations of states in relation to climate change, and in particular, the principle of intergenerational equity. The motivation for most young people in the Pacific, generally, among other things, have been because of the severity of the climate crisis, and especially for our children. The lack of action and failure of governments to address this issue in a way that reflects the realities and agency of this matter for our people. In light of the General Comment 26 by the Children's Rights Convention Committee with a special focus on climate change, this general comment provides an explicit explanation of how climate change is negatively impacting numerous children's rights. It goes through specific rights under the conventions as they relate to the environment. With all of these rights, the committee provides detailed arguments of how climate change is indeed a children's rights crisis. Our generation now and in the future deserve a livable future in light of this climate crisis, and particularly in light of these responsibilities that states have toward our children as provided in the widely ratified international treaty. But how do we do this? Out of the many actions we expect from our government leaders, there are two things that we'd like to see. Firstly, what we expect from governments in general, and in particular, we look towards Australia as a leader in the Pacific region. We need to, first of all, work on the root cause of climate change. We all know what that entails. As articulated by one of the panelists I listened to at one of the side events, and I quote, "Today's good enough is tomorrow's not acceptable." Secondly, we understand that climate crisis is a global issue, and so therefore we need to have a strong international legal foundation on addressing climate change, like the International Court of Justice advisory opinion is trying to achieve. The work on addressing climate change should not just be limited to the Paris Agreement, but it should follow on and include things like the Children's Rights Convention, Child's Rights Convention, and the GC26. So international law on addressing climate change should be based on framework on children's rights and the GC26. So states at this stage now should include the GC26 in the submission so the opinion we get is more inclusive of the children's rights as pointed by the previous two speakers. Additionally, one of the aspects of the legal questions before the International Court of Justice that Tamara pointed out is in terms of the intergenerational equity. And our children are our closest link to future generations. And so the protection of rights of children should not just be limited to the current generation, but future generations as well. And therefore, we look to our government and also the governments of Australia as our Pacific Big Brother to utilize this opportunity and make submissions to the ICJ in light of its obligations to its children and future generations. It is the young people that will inherit decisions, the laws, and the developments or lack of it that you make, and therefore do it with equity. Communities like mine and her children contribute almost nothing to this climate crisis, but we bear the brunt of the inaction by governments that have the capacity and resources to do so. And whatever solutions the governments come up with has to include the voices of the children, and especially young people as well, as we will inherit the world you create. And all we want is a livable world for our children and their children to come. As any good parent would want, the best interest of the children is their priority. And that's all we ask for, and that's what the GC26 is reminding us of. So thank you.
Cynthia, thank you. Thank you very much for this talk and for sharing your experience and your expectations from state and from legal institutions. That is very much eye-opening. I think it complements what Judge Nelson and Tamara have said beforehand, but from a different perspective. So thank you very much for that. We have nearly 20 minutes for conversation, which is great. So while we wait for everyone to pop their conversation at the chat, or if you feel like it, you can raise your hand and then turn the mic on. If you don't mind, I'll kick with the first question, touching on a theme that came from the 3 presentation, which is Article 12 and the issue of participation. So in his presentation, Judge Nelson have reminded us that the General Comment number 26 was based on extensive consultation and discussions with children. Children from all over the world have been consulted about this issue. There was an advisory group to the committee that had aiding the committee or participating in the drafting process of the committee. And we've touched upon this issue extensively in our first webinar dealing with General Comment number 26. Fast forward to the process that just ended now, COP28, and I was wondering, I think mainly Tamara and Cynthia, if you can share some of your experience as to how children have engaged or didn't engage with COP28 and with previous rounds in previous years, and what, in your opinion, can be done to improve the effectiveness of child participation. And maybe after your thoughts, we'll go back to Judge Nelson, and maybe he can share from his experience at the committee about how child participation processes can be established and then improved. So Tamara, you want to go first, and then we'll go to Cynthia and then Judge Nelson.
Yeah, thanks very much, Noam. And as I'm not actually at COP, I'll leave that very important question up to Cynthia about how can young people's voices be amplified within this important process, this conference of parties taking place annually. But I would like to say that there is ample opportunity in the lead up to COP for young people to participate. And as we know, whilst COP is the standalone event that makes a lot of these decisions around these agreements and these political and international kind of agreements moving forward, a lot of the work goes into it in the lead up to COP. And it's about ensuring that young people's voices are incorporated at those very important meetings leading up to it. So, for example, this year, as we know, one of the key things that came out of COP was the Loss and Damage Fund and an agreement on the first day about what this would look like and where it would sit. And yes, there are lots of question marks about where it will sit and the governance structure, etc. But in the lead up to it, we were Save the Children was very careful to ensure that young people had a voice about what this fund would mean and why it was important that the Loss and Damage Fund would represent children's voices and communities in Pacific countries. And so we had a lot of input at that level. And then post-COP as well, I think it's important to ensure that young people are involved in something like the Loss and Damage Fund to ensure that their voices are they're consulted and their voices are included in what the fund will look like. So as it's sitting in kind of the World Bank at the moment, what does that mean to Pacific communities? And how easy is it to access funding under the Loss and Damage Fund? If you're sitting in a country, sitting in an island somewhere, you want to raise funding, how do you go about doing that? What are the mechanisms to ensure that that funding is accessed? And what we were advocating for constantly always is that the funding should be decentralized to the Pacific region to ensure that children and communities have a clearer voice about how to access particular funding, which is aimed at them. So it's for them. Under the current funding mechanisms, such as GCF, that is incorporated. But of course, we always want to decentralize it as much as we can to ensure that the money is really reaching who it should be reaching. Thanks, Noam.
Thank you, Tamara. And more information, as you saw, about the Loss and Damage Fund can be found on the chat. So thank you for that. Cynthia, do you want to jump in?
Yes, just quickly, just supporting what Tamara said. I think there's a lot of work that was put into ensuring that young people part of the processes. However, we're all aware as young people of when we see that it's not meaningful and it's mostly a lot of tokenism. So we need to sort of move past that as well. That is one of the challenges, us identifying that and pushing for more meaningful participation.
Thank you. Tokenism is also always the risk in child participation processes. Let's be reminded also that Laura Lundy, expert in child participation, was trying to advocate in favor of tokenism or suggesting that tokenism is an adult perspective of child participation. So I'm grateful for Cynthia to share her perspective, what tokenism looks like from a young people's perspective. Judge Nelson?
One thing that on the issue of child participation, the committee, of course, meets in Geneva, and we have the opportunity to speak to children, but on a very limited basis. I mean, firstly, it's a long way for children to come, and sometimes talking to them online is very difficult because they're in remote parts of the world. And we usually spend maybe at the most 45 minutes to an hour for every meeting talking to children. But one of the things we learned by bringing the committee and having a special session in Samoa a few years ago was that we were able to there was much more child participation. I mean, we not only had side events involving children, but we actually had a session on climate change that was facilitated and conducted by the children. And we were the spectators, if you like. And they actually ran the program on what they wanted to discuss about climate change issues and problems. And it was very enlightening for us adults. It was quite something to see that they were more than capable of conducting a session. And I mean, what that experience showed me is that there is a case to be made about regional discussions on the ground, you know, bringing the committee to its stakeholders, to the children, rather than, you know, at the moment we are thinking the other way around. We're thinking the children go to the committee. But maybe it's time to think in reverse, that we should seek ways for these international bodies and these international organizations to come to the children. And we found from that experience, it was so beneficial, Norm. It really was. And it was one of the resounding successes was the level of participation of children.
Thank you very much, Judge Nelson, for that. I think let's continue with that theme and moving forward about the utility and opportunities of general comment number 26 and the opportunities to engage with global processes. And we at the beginning it was said that we are looking at how Australia can implement and exercise its obligations to its Pacific neighbors. Tamara, will you be able to shed some light as to civil society engagement in the reporting process to the UN Committee on the Rights of the Child as Australia is coming to its next engagement with the committee and any attempts to engage with children in the shadow report processes? And the same token, Cynthia, if you can tell us what your organization is doing or is planning to do in engaging with the committee in the future or with other bodies on the international level.
Thanks, Noam. So Australia, Save the Children Australia has a domestic program called 54 Reasons, and as part of their work with the domestic policy, they are undertaking a consultation process to support that, to support the Australian government. In the Pacific, we have recently supported Save the Children Papua New Guinea, who have released as part of their CRC 30th anniversary, they've released the annex, which has been fantastic. It's been 2 or 3 years in the making. And Claire, if you can't access it, let me send you a copy after this conversation, but it is around and it's a very important document. So we marked CRC 30 in Papua New Guinea. We released the annex and Save the Children with the government made a commitment to move forward and see how we can support things like GC 26 being included in future conversations around the rights of children in Papua New Guinea, specifically in areas like child protection. One of the other ways that we're looking at supporting that is the Australian government made an announcement last week that it was going to commit $100 million to the Pacific Resilience Facility through the Forum Secretariat, which is a fantastic achievement for the region. So we have that commitment. We have the political will. The next step is how are we going to incorporate civil society voice within that? And what we're advocating for is, given that organizations like Save the Children, the Pacific Island Students Fighting Climate Change, have that inroad into the community groups, into the voices, how is that going to be reflected in a political institution like the Forum? So we're looking at how that might look and supporting movements for civil society to have seats on whatever board or governance structure there is to ensure that those voices are represented at that level.
Thank you, Tamara. Cynthia?
Just to add on, apart from our partnership with the Australia Save the Children, I think one of the important challenges that Justice pointed out was the awareness and education on the children's right, and that is sort of a second objective for the Pacific Island students, and we're looking to building that more progressively in the coming years, because we do have the networks and we are on the ground. So that is our second objective, and we'd like to build on that with the guidance of CRC 26 and also partnership with Save the Children.
Thank you. So yeah, I mean, informing and educating children about their own rights is probably like, one of the most important prerequisites for any meaningful engagement in these processes, as highlighted as well by Justice Nelson. Coming back to you, if I may, one issue that came up at your presentation, it also featured the general comment, is the need to have an impact assessment. of environmental programs or projects or policies or legislation, and to see how they affect or might affect the rights of children. And I have to say there are not any good examples around of how it needs to be done. And if someone has the will and the budget to do so, we can share any good resource with them. So I was wondering if, from the top of your head, you have some ideas as to how this process can look like or should look like, what should be taken into account, and what the outcome of this impact assessment process might be.
Yeah. Thank you, Norm. Look, I'm trying to think off the top of my head which country was it that came to the committee and impressed us with their child assessment impact assessment report. It was a European country, but I just, for the life of me, cannot remember. But certainly, I mean, to some extent, it depends on the area that you're targeting. For example, if it's education or health or violence against children, that would be the determinant about how you go about the assessment. And that would be the first thing. The second thing would be that what I do recall from those assessments is they were comprehensive in the sense that they not only involved NGOs, but they actually tried in their own way to reach out to children's groups, to have some input from children. And I think it was because it was education, it was an education policy of some kind that they were trying to introduce. But certainly, as wide a group as possible was their sort of operating strategy, which was, I think you can't go wrong. It's much better to have too much information than too little. But it would depend very much on the area that you're targeting. And of course, if you're talking about legislation, then it becomes even more technical and more specific, where you would be engaged in trying to consult on the benefits and the pros and cons of a new law, for example. But I wish I'll certainly keep it in mind. I'll look it up. It's worth looking up because, as I said, very few countries came to the committee and showed us that they do a child rights impact assessment. The majority of countries just don't do it, but we advocate for that it should be done all the time. But we don't sort of provide a guideline or a model, to countries on how to do it, as you say. I mean, how do you do it? It's a good question. But if I find it, Norm, I will certainly put it to one side and send you a copy.
I'll keep my eye open. Thank you very much for that. Tamara, I'll put you on the spot here. Do you have any good examples from SAVE, or is SAVE in the process of developing such a model for an impact assessment?
Yes, Noam, we are in the process of looking at how we might best do that. So watch this space, and we'd love to have a conversation with you about how we can progress this, and Justice Nelson, because this is a really important consideration and definitely a priority for us for 2024. So we can open up the conversation to whoever's interested, and we can start looking at what that might look like, and to support GC26 as well.
We are here, and I'm sure that Judge Nelson will be happy to contribute to this discussion, as well. And thank you, Susan, for posting that link for UNICEF toolkit about how their views about how a rights impact assessment might look like. We are coming to the end of the webinar, and I appreciate the fact that there are very few people have contributed to the chat. If anyone has a question or a comment that they would like to make, that would be your opportunity now. Acknowledging the comments we had from our colleagues in Bangladesh and the impact of climate change and climate catastrophe on the indigenous communities and children in Bangladesh, and that had been highlighted by research over the last few years as well. So acknowledging these contributions as well. And we are drifting towards the end. So it's time to thank the Diplomacy Training Program for making this webinar happening, especially Andrei Frankovich and Claire Sidoti. And thank you everyone for logging in and to show your interest and supporting this project. And I would like to ask all of you to join me in thanking our three speakers for today: Justice Clarence Nelson, Tamara Logan, and Cynthia Honuhi. Thank you very much for your time and your effort in participating in today's webinar, and wishing you all the best. Thank you very much.